This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, Todd Lutsky is with us now for Ask Todd. This is your chance to ask Todd your estate planning questions. Studio line is open at 888-205-2263, so get dialing. I know it's a new year, so this is your chance to ask Todd your questions to get your estate plan squared away in 2025. Again, 888-205-2263. Usually have time for 2 or 3 questions. So get dialing to make sure that you are in the front of the line. Again, that number is 888-205-2263. Mr. Lutsky, how are you doing today?
I am great. How you been?
A little confused.
Yeah, it happens.
Was out yesterday doing a little bit of running, jogging on the track. And I saw that there was a clam over on the side of it.
A clam?
Pulled a muscle.
Yeah, that happens.
Real problem.
It is a problem.
Real problem in this weather. Todd, I want to talk to you a little bit about the age at which it's appropriate to consider long-term care planning and trying to protect assets from the cost of long-term care. Specifically, is there ever an age that someone gets to where you say, hey, like you might be too old to consider this kind of planning? Is that a thing?
I think we should talk about the high end and the low end. Let's do that.
Sure.
So on the low end, right, when clients come in and they wonder, what do I want to do estate planning, but, then our job is to guide them, as to what kind of estate plan makes sense. And so we'll generally, age is one factor that we look at. So if you come in and and this is just my own number, by the way, there's no book telling us this, 60 and up, I'm going to ask. 60 and up, I'm probably going to say, are we concerned about the future and potential long-term care planning? Because we all know it takes 5 years to protect it. So if I can have this in my rearview mirror by 65 or by 70, I want to do that. If you come in and you are, 50, but you tell me, you know what, I got, diagnosed with Parkinson's, or I have, MS or something that might affect mobility, well, then you might want to get the clock started sooner rather than later. But those are, the exceptions to the rule. To your point, what about the other end? Well, I hate to put a cap on the other end because, I'm always betting on you living, not on you dying. So
it's nice of you.
Yeah, that's what I do. So, if you came into me and you're 85 and you say, geez, I want to start my Medicaid clock running. Well, you know what? That's okay. I'm going to say do it. I hope you make 90. And if you do, then and something happens then, you'll be protected, and that's important. Plus, there's never a downside to having the clock running, right? If you have the clock running and somebody gets sick, 4 years into the clock, well, I might want to just private pay for 1 year. If I can guarantee the protection of the, dollars or assets that I've transferred, and I only have to pay one year, say $110,000, $120,000, I might do that if I'm protecting $500,000 or $1 million home or whatever it is I've done planning for.
Sure.
Makes sense. So getting the clock running never hurts. And, of course, I'll share with you the story that I did do. A 94, 95-year-old came in and they needed trust planning anyway, just from an estate planning standpoint. So I said, well, then why not just make them irrevocable, and then you get the best of both worlds. Sure enough, it worked, and they didn't get sick until they beat the 5-year clock. So never hurts to get it done. I guess there's not an age, that's too old to do the planning. How's that?
There you go. Talking with Todd Lutsky from Cushing & Dolan. Still got a little bit of room on the phone lines. I know we already got a couple people that called in. But, again, 888-205-2263 is the number. Again, 888-205-2263. We're going to take a quick break right now, but then it is your calls with Todd right after this. That number one more time is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Let's get right to your calls with Todd Lutsky here. First in the queue is Philip on Cape Cod. Philip, what's your question for Todd?
Todd, you did an irrevocable trust for me about 6 years ago. I have rental property. If I sell the rental property, can I take some of that money out? Because I've not enjoyed any of the rental income to this date.
Well, let me ask you why you have not enjoyed the rental income first and foremost.
Well, at this point, I thought it'd be better just to keep it in the trust in case we needed some money for repairs on the property.
Okay, so first and foremost, and I get it, not everybody remembers everything you talk about in meetings, but the trust is an income-only trust, and all the rent belongs to you every single year. And you've been picking it up, I'm sure, on your income tax return, and it belongs to you and your family. So that rent is yours. Now, having said that, my next comment would be, how long, you said 6 years you've been renting this, right?
Well, we've been renting it longer, but it's been in the trust since we met with you,
and
over 6 years.
Right. So the good news is that in our trust we have language that says all the income shall be distributed to you. But I get it. Some people don't physically take the income out and put it into your personal bank account, although you're certainly entitled to it. And so we have language in the trust that says that doesn't go to principal if you don't take it. It doesn't revert to principal. It's basically an account receivable. Okay? So if you were earning, if this thing generated, $60,000 a year in rent, okay, then you have 6 years of $60,000 a year, so 60 times 6, of technically an account receivable. Now, I get it. You might have used some of the money to pay for real estate taxes or some upkeep or maintenance. I get it. All that money might not be there. But you're getting the drill, right? You're getting the feel. So you need to find out how much income, and you can just look on your tax returns. It'll be there. Find out how much income got deposited in that trust over 6 years. And that's one big account receivable, right? So 6 times 6 is $360,000 of money. So you're allowed to take that because it's still income. It's not considered principal. So that's how I would go about taking it out. How much you looking to take out?
Believe it or not, I'm like $100,000 will get me over the hump.
All right. So there you go. I think even before you go to sell it, there's probably money sitting in that trust bank account, correct?
Yes, there is, sir.
Yeah, so probably a lot of money because you haven't taken it. So I suspect that you now have the ability that if you did that, and I said there's $360,000 of income, certainly $100 is not going to be a problem to take out. And that's how I would go about it. It is an account receivable for you. Then when you sell the property, again, it's completely a grantor trust, so you have the ability to sell it. It's flexible. You're going to have no adverse income tax consequences, although I recommend you use our firm to help you with the closing so that you don't screw up the 5-year waiting period, which you will not, right, as long as the money gets put in the trust. And therefore, that money you probably can just leave there and continue to be protected and not have to worry about grabbing the principal because we figured out how to do it. So hopefully that helps a little, and you can see, and everybody can see, the flexibility built in to these irrevocable trusts. So hopefully that's helpful, Philip. Folks, sometimes people that do their planning, like Philip, and others who don't, find themselves faced with nursing home care nevertheless. And so for either group, whether you've done your planning or not, if you find yourself faced with a nursing home, there's going to be assets outside the trust if you've done your planning that are at risk. And there's going to be folks who didn't do their planning and all their assets are at risk. Get this guide. It's getting close to the end of the month. Long-term care planning for procrastinators, and it will teach you how to make countable assets non-countable last minute. And each asset is differently treated for married versus single people, whether it's a home, a rental, or money itself. So get the guide, 866-848-5699 or legalexchangeshow.com. So don't just write the check to the nursing home, 866-848-5699 or legalexchangeshow.com.
Todd, we got another caller for you here. Let's go to Gail in Worcester. Gail, you are on with Todd Lutsky.
Hi, Todd. I have a question. I understand that in the state of Massachusetts, a TOD for real estate is not valid. Is that true?
Yeah, I don't realize. So, folks, what you need to understand about a TOD is it's a transfer on death, and you normally see that at the bank account level. Not even so much at an investment account level. You see it at a bank account level where it's similar to a designated beneficiary on a bank account that says, when I die, I transfer this account on death to, and you put a name down. But that is for a bank account and perhaps an investment account, but not that I'm aware of anyway for real estate. So to avoid the probate on the real estate, whereas a TOD will avoid the probate on a bank account, for real estate, I think you need to really do some trust planning and figure out how best to avoid the probate, protect the asset, and get it to your family. So hopefully that was helpful.
Todd, I got one more for you here. Let's go to Jim in Haverhill. Jim, you are on with Todd Lutsky. What's your question?
Hi, how you doing, gentlemen?
Good.
My question is pretty simple. Can you put a house that either has a mortgage on it, or maybe even a house that has a reverse mortgage on it, into a trust?
Well, what kind of trust? Revocable or irrevocable?
Either one. Probably the irrevocable. Seems like you lean towards those more than the revocable.
Well, and I think it's fair that you would say that. I don't want to say that I lean towards one or the other. It's strictly a function of what makes sense for the particular client and their situation. So we can try to address both if we have the time. But, revocable trusts are less problematic when you're transferring encumbered property because pretty much you're still the owner, right? And so you don't have to worry about triggering a due on sale clause. So you could transfer it in. And even refinancing inside a revocable trust. I mean, banks sometimes give you a little headache, but ultimately what will happen is the bank might say, okay, take the house out of the revocable trust, put it in your name, get the refinancing done, and then put the house back in the revocable trust, and that's fine. They don't care. So from a revocable trust standpoint with a mortgage on it, I don't see any issues. The irrevocable trust, if it's encumbered property, then yes, you have to take a couple of steps. So if it's your primary residence, what we do, and we talk about life estates a lot, we've talked about them over the years. A life estate is something I use infrequently, but would use it, and I'm going to say to really everyone else, planners and the like, should use it when you're transferring an encumbered primary residence to an irrevocable trust. Okay, so if you do that, if you don't do that, you don't reserve the life estate and put the remainder interest into the irrevocable trust, you could, if the bank ever checked, trigger the due on sale clause. Okay, unlikely the banks ever check on these transfers as long as you pay, but nevertheless, it's an issue. So there's also the Garn-St. Germain Act that says you might not trigger it, but the easier thing to do is say, you know what? If I reserve a life estate in the deed, then I have the right to live there the rest of my life, the right to collect the income, and the right to pay the bills, hooray. So that's the nugget of ownership that I kept, means I cannot trigger the due on sale clause, okay? So I cannot trigger it, and I can keep my existing mortgage by transferring it to the trust and reserving a life estate, and I don't have to worry about it. Now, the issue that becomes with that is, well, you can keep your existing mortgage. You're not likely going to be able to refinance it, right? If you try to refinance it, the bank is likely going to make you take the whole thing out of the trust and reset the 5-year waiting period. Now, I can tell you that a lot of my clients that have done this, of course, in the past, have what? Very low rates. And today, rates are really high. So, one, we don't want to trigger the due on sale clause, so we reserve a life estate. And two, they're really not going to be refinancing. So, and mostly, I can tell you folks that people that do irrevocable trust planning don't have mortgages on it. But we can solve that problem for you. And if it happened to be on a rental property, you just got to keep a 99-year lease. I can explain that in detail, and that will prevent the triggering. So long-winded answer. Sorry for that, but I hope it's addressed the question.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.